is where we have seen the development of the law by the Constitutional Court. This is the context for my point that I want to make. So, as the law gets developed, it's very important for us to ensure that the rules are also strengthened to be inconsistent with the law, because our sole aim is to ensure that we are closing any room that would be available for one to compromise the quality of the results. So, in the first instance, there is a court judgment where the applicant applied in the Constitutional Court, asking the court to nullify certain provisions of Births and Deaths Registration Act. And those provisions were relating to the issue of surname after getting married. And the first section was saying after the marriage, the wife is the one that has to change the surname. And the second section was prohibiting the husband to assume the surname of the wife. And from that day, because it was delivered by the Constitutional Court, it became the law. From that day, it was last year, in 2025, you can find that on Google. So it became the law. We saw the development of the law. And then the second one is the one that is relating to the issue of the maternity leave. Again, the applicant applied to say what the Basic Conditions of Employment Act is saying when it says there has to be a maternity leave for the mother of a child. Is actually discriminatory, because that one is giving a full month's maternity leave to the mother of a child, but only giving 3 days to the father of a child. And to the surprise of many people, the Constitutional Court came with a judgment that favored the applicant. And from that day, it became the law, because the court said, directed the parliament to change the word maternity to say it has to write paternity, in a sense that when the baby is born, the father is entitled to the 4 months leave, which the mother is entitled to. Okay, colleagues. Okay, colleagues, the reason why I am bringing the instances, yes, the reason why I'm giving the instances of the development of the law, I want us to ensure that the rules are also developed. There is a certain provision of our rules, the one that says the candidate who comes to the examination room under the influence of alcohol, provided that the candidate is not causing disruption, the candidate has to be allowed to write the exam until the end of the session. So I need to suggest, colleagues, that we review that provision on the basis of 3 grounds that I'm going to list. The first one is the legal position of a person who is under the influence of alcohol. The second one is the constitutionality of the rule itself. The third one is the consistency of the rule with the ones that we read for the candidates in the exam. So starting off with the first one, the legal position of a person who is under the influence of alcohol. Legally speaking, colleagues, a person who is under the influence of alcohol is taken as a person who has a limited capacity to act. In other words, the person is equated to a person who is mentally ill. The person is equated to a person who does certain acts while the person is sleepwalking. And the person is equated to an infant, legally speaking. That is why if you were to look at the criminal law cases, A person, if for example you are under the influence of alcohol, you take your gun, shoot to kill someone. In the court of law, during the trial, the person can raise a defense to say, I never intended to kill the person because I was under the influence of alcohol. So intoxication, colleagues, is a legal justification for a defense. That is why in criminal cases you've got a murder and a culpable homicide. A person who does a thing while is under the influence of alcohol can never be convicted for a crime of murder. The person can instead be convicted of a crime of a culpable homicide. So the reason why I'm putting that, colleague, is because if the candidates